And thank you for joining us today for our webinar on the role of the tribal court judge. My name is Rebecca Horsechief. I'm Osage from Oklahoma, and I am the program coordinator for the National American Indian Court Judges Association. I'll be moderating today. We want this to be an interactive experience, so please feel free to ask as many questions as you want throughout this webinar and make use of our chat feature and answer the polls as they pop up throughout the webinar. I'll be introducing our presenter today. John Traylor, Judge John Traylor, is the presiding judge for the Gila River Indian Community Court of Appeals. He is the chairman of the Tribal Ethics Committee for the 3 affiliated tribes of North Dakota. Judge Traylor has extensive experience as a presenter. He taught federal Indian law at Boise State University. He has made multiple presentations on the Indian Child Welfare Act. In 1978, he wrote a book about the Indian Child Welfare Act entitled A Practical Guide to Understanding the Indian Child Welfare Act of 1978. He's made many presentations on bail bond law in Idaho, and he has taught 2 classes for NAICJA at 2 of its annual conferences. After retiring from government work, Judge Traylor started a consulting business, John Traylor Tribal Court Consulting, that focuses on tribal court operations and improvement and continues with that business. He's also a member of the Pasquayaqui Tribal Bar Association. And with that, I will hand it over to you, Judge Traylor.
Thank you, Rebecca. I'd like to welcome all of you to this webinar. Of course, it's titled The Role of a Tribal Judge, and that may seem like an obvious question with an obvious answer. But I think that there's a lot more to it, and I think that's the purpose of having this webinar today. As we get into this, we'll talk more about some of the specifics about the role of a tribal judge. Jessica, I would kind of like to start by getting a feel. I see that we have about 10 participants. I'd like to get a feel for their capacity at this point. In other words, how many of these are tribal judges? Do we have any advocates or attorneys, tribal attorneys, council members, etc.? Are we able to do that?
Sure. Let me just do a quick poll here for you. All right, let's see what people have to say. So I just did a quick one. What is your role? Judge, administrator, attorney, advocate, or other? And if you're other, I'm going to just ask you to type in chat, please. Thank you. I'll broadcast these results so folks can see them.
Looks like we have a lot in the other category. Glad to see that we have one judge. Technical assistance, okay, BJA. Okay, good. Appreciate that. Gives me a feel for who we're talking to. So we're going to talk about the role of a tribal judge, and when we do that, some of the things that I think are important is that we talk about the judicial branch in general, and we'll also talk as we proceed here the differences and similarities between a Native American or tribal court and non-Native American courts in general, specifically the federal and the state courts. Our objectives today are several. We're going to discuss the role of the tribal judge, of course. I want to just spend a brief moment reviewing judicial structures at the federal, state, and the tribal level. I spent probably 25 years as a court administrator, 4 of those as a tribal court administrator, but the rest of that time as a state court administrator in Idaho and in Arizona. And I've seen the various structures at the federal, state, and tribal level. We'll just touch on those briefly. Again, we're going to review the similarities and differences between these jurisdictions, a brief history of the creation of our judicial system, meaning the federal system. And that's important because, as we all know, the state system mirrors the federal system, and a lot of tribal courts mirror those systems as well. We'll just discuss briefly exactly who is a tribal judge when we talk about the role of a tribal judge. We're going to discuss what should not be a part of the role of the tribal judge. I think that's important because it's easy to say what should a tribal judge do, but I don't want to exclude some of the things that I think we should be sure that a tribal judge should be aware that they should not be doing in their capacity as a judge, or something that at least may raise a question of appropriateness. And then, of course, we'll discuss what should be the role of a tribal judge. And we're going to close at the end of this session. I'd like to know from some of you what kind of roles your judges play. I've been in various tribal courts, and I know that judges play multiple roles beyond just being a judge, and so I'd like to have some discussion about that. When we talk about the Native American or tribal court and the state and federal systems, I drew this little chart to do a comparison. In state and federal courts, over on the left-hand side here, they provide a forum for civil disputes. Excuse me. And do tribal courts do that as well? And I put yes, they do. Secondly, they judiciously exercise statutory power, and tribal courts do that as well. They exercise constitutional power, and yes, for tribal courts as well. Many judges assist in training and assisting new judges. I've seen that role played by tribal judges as well. They provide a forum for criminal prosecution, and that's a given in tribal courts. Then they meaning the federal and state courts, they serve as an equal branch of government. And I put a question mark there because I'm going to go out on a limb, and it's been my experience that most tribal courts do not play this role. Some of them do. I believe the Navajo Nation, for one, constitutionally, by their own constitution, is a separate and equal branch of government. And I know there are some out there, but there aren't very many. The state and federal, they provide checks and balances in government. Again, unless they're a separate branch of government with specific powers, tribal courts normally don't do that. And they protect the rights of citizens, and yes, tribal courts do that as well. Alexander Hamilton, paraphrasing, said that the judiciary is the least dangerous branch because under the Constitution, judges would possess neither force nor will, but merely judgment. And I want you to keep that in the back of your mind, specifically if you're a tribal judge, that this is the real role of judges in any system. Exercise judgment, not force and not will. You know, I did some research for a different cause years ago on the U.S. Constitution, and I was trying to figure out where the Founding Fathers came up with the representative government form that we have today. And what I found was very interesting. Benjamin Franklin spent a lot of time consulting with the 6 confederated tribes in New York, the Iroquois Nation, because they had a representative government system because they were a large tribe spread out over a large geographical area. And he even had them come to the newly formed early Congress to talk to them and explain how that system worked. And believe it or not, the Founding Fathers borrowed heavily from the Iroquois Nation system of government. I didn't get into it at that time on whether or not they adopted some form of the tribal judicial system or tribal dispute settlement system or not, but I found that to be very interesting. So the U.S. Constitution, they created only the U.S. Supreme Court and left to Congress the power as needed to create the lower courts. So that means that the 9 justices of the Supreme Court are constitutional officers. All the other judges are not in the federal system. They are basically legislatively created, and that was done by the Judiciary Act of 1789, which also created, by the way, the United States Attorney. Now, virtually every state we know in the United States is, by its structure, a virtual image of the federal judicial system. They both have limited jurisdiction. That would be the federal magistrate. They both have courts of general jurisdiction. That would be the federal district court. And they both have intermediary appellate courts, the circuit courts of appeal. And they both have a Supreme Court, and New York is the exception because they do have a higher court. It's called the New York Court of Appeals, but it is not called the Supreme Court. And state courts, that's a typo, it should say, and states in general, the legislatures, have universally adopted the federal system of the 3-branch government, where the state courts fulfill the same function as the federal court as an equal branch of government designed to keep an eye on the other 2 branches. Very few tribes have a government that involves, 3 equal branches. Normally, the council serves as both the legislative and the executive branches in many tribes. And in many tribal constitutions, the tribal court is not an equal branch of government, but is created and controlled by the council, exercising its authority granted to it by the tribal constitution through typically a law and order code. And unless tribal law permits, most courts have no jurisdiction over any actions of the council. Council can't be sued without its permission. So I have a question. Is this any different than federal or state court systems? And my answer is no. You can't sue the federal government or a federal agency without the federal government's permission because it is a sovereignty. You can't sue a state or a state agency without the permission of the state government for the very same reason. And you can't sue a tribal entity or a tribal council without their permission for the very same reason, and that's been made very clear by the U.S. Supreme Court. So when people complain to me who don't understand a tribal system that they can't sue the tribal government, and that's not right and that's not fair, I simply say, well, the same thing applies in federal and state court, and that seems to end the discussion. Now, unlike federal and state courts, the tribal court can at times apply custom and tradition in deciding cases. And I've seen this in a number of tribes. Some of the Alaska tribes have a very good system of doing this, and I think that's very impressive. But I have a question is, do you believe that a tribal judge should apply tribal custom and tradition anytime the tribal judge feels like they should? I think you can answer on the chat line. Is that right, Jessica?
That's right. Go ahead and type your answer into chat. So the question is, go ahead.
The question is, should a tribal judge apply tribal custom and tradition anytime they feel it is appropriate? We have 2 yeses. Now, the way I would answer this question is yes, if they have been granted that power and authority through their law and order code or their constitution. I think it's inappropriate for a judge to do things that may affect the outcome of a case unless they are clothed with the authority to do that. Particularly applying custom and tradition, because how are you going to apply custom and tradition if you don't have an organized system or structure that tells you as a judge how to do that? Who is going to be considered an expert in tribal custom and tradition? And as a judge, you're not in a position to do that, and you shouldn't be doing that. I know it was kind of a tricky question because I didn't give a lot of details in that. But one of the main emphasis of this webinar is that tribal judges, all judges, state and federal as well, but tribal judges, in my opinion, should not do things on the bench or as a judge unless they're specifically clothed with authority in some fashion to do that. Now, who are we talking about today when we're talking about a tribal judge? We assume that a tribal judge presides over hearings and trials. They hear testimony, they rule on evidence and objections, they make decisions, render verdicts, create and sign orders and judgments, and attempt to resolve the cases. This is a picture of the traditional non-Native American judge, and many law and order court judges follow the same pattern. So, as we said earlier, many tribes have adopted a federal inspired judicial system, and many tribes have what's called, I'll call it a judicial council, or a separate body that oversees the actions of tribal court judges. They take complaints against judges, they take action against tribal judges if they violate, for example, a code of ethics or a code of conduct. And of course, they copied that from the state and federal system as well, and I think that it's a good thing to have. One of the things I meant to say at the beginning of this webinar is if anybody has any questions, please feel free to interrupt at any time and ask that question. I would love to hear from you if you have any questions or comments. But we'll also include in the definition of tribal judge special hearing officers or elders, for example, like in Alaska, who don't sit on a traditional judge's bench. They don't wear a judge's robe. They sit around a round table. They still serve the same function as a judge, but they actually serve as a mediator as well. And we'll include the appellate judges at the tribal level, judges pro tem. Some of their major duties may be different from the trial judge, but much of what we discussed today, in my view, will apply to these judges equally. So before we start talking about the role of a tribal judge, let's talk about what I feel a tribal judge should not do, or things that should not be included as part of the job. And to demonstrate this, I've created some hypotheticals, situations. I have a couple of these. And let's talk about the first one. I think when I applied to be a judge for the Gila River Court of Appeals, I had one of the members of the committee ask me an interesting question. What do you think a judge should not do? What is inappropriate? And the first thing that came out of my mouth is a judge should not be an activist. And we'll talk about that in more detail as we get through this hypothetical. Judge M is a card-carrying member of the NRA. Joe was cited by Tribal Fish and Game for having an unregistered rifle in violation of the tribal ordinance that required all firearms on the reservation to be registered. Judge M regularly imposes the minimum fine on such cases, while other judges have been stricter. When the prosecutor raised this point at sentencing, Judge M raised his voice and said, "It is my belief that citizens should not have to register guns, as it's a violation of due process, and the law needs to be changed." So Jessica, I think we created a poll question for this hypothetical. Are you ready to post that? Yes. So if you could just quickly answer this on your computer, do you believe the judge's comments were inappropriate in this setting?
Okay, it looks like everyone's completed the poll.
Okay. It looks like a vast majority said that they felt the comments were inappropriate in this setting. And I designed the hypothetical to be a little bit vague, but realistic. Throughout my years working in court systems, I've seen and heard some judges say and do some pretty crazy things that were definitely inappropriate. And sometimes they got in trouble and sometimes nothing happened. But I think in this case, what the judge is doing is stating a personal opinion that specifically has an impact on a defendant in a case before the judge. And one of the things I believe a judge has to be at all times is unbiased and must leave their personal prejudices and opinions. They must check them at the door when they become a judge. We all know that judges are held to a different standard than the rest of the world. A lot of my judges that I worked with at the state level didn't even want to go out with their friends or their other judges after work to maybe have a drink or even to dinner. They just didn't really want to be seen in public. One of the other things that judges should be careful about is attending political rallies. And the line gets even thinner when it asks the question, what about financial contributions, for example, to the NRA? If Judge M didn't say anything, but somebody found out that he was a card-carrying member of the NRA, for example, or that he made political contributions to the NRA, do judges lose their right to be citizens when they become a judge? You know, judges, I'm going to have to say, I think they're probably all registered as Democrat, Republican, Libertarian, or something else. But judges have to be careful in how they let that information get out in the public and how they let that information or that affiliation impact their decision and their job. So let's move on. I don't think judges should have personal-driven agendas, much like Judge M. Judges, I don't think, can be political. I don't think they should be attending political rallies. I don't think they should endorse candidates at any level of government. They can't be biased about justice issues. Some judges have pretty strong opinions about who should be prosecuted, how they should be prosecuted, if at all. Judges should not give advice to litigants. That's patently clear. They should not abuse their power or position. I was doing consulting for a tribal court one time, and one of the tribal judges helped a litigant fill out an application for some sort of an order after hours on a Saturday. That was not a good thing to do, and the judge got in trouble for doing that. That's an abuse of power or position. Judges should try to not be egotistical or self-centered. behaving rudely or disrespectfully towards litigants, court staff, counsel, witnesses, or anybody. Being a judge is not what I would call the easiest job in the world. They have to face a variety of people in court, sometimes arrogant attorneys and advocates, prosecutors, and sometimes disruptive parties. And the judge is expected to rise above all that and not behave rudely or disrespectfully, even though somebody might be being disrespectful to the judge. And again, we talked about personal prejudices. You know, I used my entire career was spent supervising staff. And one of the things I told my staff was, people are always told, leave your problems at home. And I told my staff, that's impossible to do because it's part of you and it's part of who you are. But what I expect out of you is that you hold that in check. You hold those emotions and those personal issues in check when you're at work. Judges are going to have personal prejudices. That's exactly why judges that are going to get appointed to the federal courts and some state courts, they get grilled a lot by the appointing bodies. They try to get them to answer, what do you believe in this? What do you believe would happen in a case like this? And they try to pry into a judge's personal prejudices. Everybody has them. But when you become a judge, you have to rein those in and keep those under control when you're performing your duties.
Judge Traylor, I have a question about Judge M in the hypothetical.
Yes.
If he had made that comment not during the sentencing, but just back in the break room chatting with that attorney, would that have been okay? So was it that he said it during sentencing that was the real problem?
And that's an interesting question. And one of the hypotheticals we're going to get to has a similar scenario, a little bit different. But no, that's a great question. Because I guess the question then becomes, if you said it to one person, let's say it's an attorney or even a staff member, and this happens, judges do it all the time, and I've seen it played out in tribal courts. They state personal opinions about things that may or may not come before them. So I guess what I would have to say is if the judge says something like that, I think it's incumbent on the judge to be sure that they're aware of that. And in any cases that come before that judge where that statement comes into play or it is at issue, like the NRA, I think that judge has to recuse himself from hearing those cases. So it's a fine line when you're talking about judicial ethics and judge behavior, particularly if you're not currently sitting on the bench. What not to do, don't show favoritism towards litigants. Let's look at this next hypothetical. Judge Jones is a former prosecutor of 23 years. He developed a keen sense of when people were lying and developed a firm belief that defendants usually lie and police officers mostly tell the truth. At a felony trial, defense counsel presented substantial evidence to show the citing officer was in fact lying under oath. Ruling on a motion to exclude certain evidence submitted by the officer, the judge said, you know what, I've worked with a lot of criminals and most of them lie. Motion denied. So would this be inappropriate? And there's Jessica's going to put up the poll on this one, and you can answer yes, no, or other. In this particular setting, do you feel the judge's comments were inappropriate? Yes, it looks like everybody's going to agree on this one. Now, the question I have for you is, the judge was ruling on emotion. What if the judge was the trier of fact? In other words, there was no jury, and the judge was the trier of fact, and just before making his decision known to the counsel and the parties, he kind of talked about the evidence that came before him. And he said, you know what, I'm the trier of fact. I have to decide who I believe and who I don't. I have to decide what the evidence presented leads me to believe, much like a jury does. So I'm openly telling you that I think the defendant is lying. Now, would your answer be differently if that happened? So I don't think we need a poll on that. But you see just a little bit of twist in the facts, in my opinion, which changed the outcome. I think that a judge who's sitting as the trier of fact and said something like that, specifically, not what we have in this hypothetical where all defendants lie. I think if the judge says, I think this defendant is lying, I think that would be appropriate. That's what juries do. And if you're the trier of fact, that's what you do. But a blanket statement to say most of them lie, and therefore I'm not going to grant your motion, I agree with what everybody else is saying. I think that was pretty inappropriate. So let's move on to the unethical behavior, what a judge should not do. Hypothetical number 3. Judge Smith worked in a tribal court in Wisconsin. After conducting a pretrial conference with attorneys of the parties, one of the attorneys on his way out told the judge he had extra tickets to the Brewers baseball game on Friday. He handed them to the judge and said he could not use them because he'd be out of town. The judge thanked him and took the tickets so he could take his son to the game. Nobody else witnessed this exchange. Do we see any problems here? And I think Jessica has a poll for this as well. Okay, I think everybody agrees with this, and I agree as well that it was probably inappropriate. Judges have to avoid the temptation to be part of the good old boy crowd or to have too close of a relationship with any advocates or attorneys that practice in the jurisdiction. I think the appropriate answer in this case, the judge should have said, no, thank you very much, I'll have to pass, and just let it go. So in this case, I specifically put down here as part of the hypothetical, nobody else witnessed this exchange. What I was trying to say is there anything wrong here, really, if nobody else saw this? And to me, somebody did see it. The attorney giving him the ticket saw it. And to me, that's critical because it may have been interpreted that the judge's actions are going to result in favoritism towards this attorney and any of his clients. And further, what if this attorney shares this exchange or this experience with other attorneys or court staff? Do they now think that they'll fare better with the judge by giving him or her a gift in the future? And what does that do about the judge's reputation in front of this attorney as well as other attorneys or people that this lawyer may have shared this experience with? So we're not here to talk about judicial ethics, but when I was compiling the list of things that judges should not do, unethical behavior was one of the things that stuck out in my mind as very important for tribal judges to avoid. And the last thing I'm going to put under the don't do that column is meddling. I consulted for a court before where the chief judge could not keep out of the business of the court administrator. She would come out into the clerk's area, and they were under the supervision of the court administrator, and she would tell them to change the way they're filing things, change the way that they're processing paperwork, and not even talking to the court administrator. This puts the court staff in a very tenuous position, and the chief judge did not have any legal authority to supervise or order the clerks around, and that kind of made the whole thing worse. And the clerks, the mentality of the clerks, the atmosphere, the clerks were really put in a bad position. And this judge used to work in probation years ago before she became a judge, and she was also trying to regulate how the probation office should be doing things, just overstepping the bounds. She did the same thing with court security and law enforcement. And needless to say, the court staff are very unhappy because the tribal court administrator would not go to the chief judge and privately have the conversation that she probably should have had, and that is basically stay out of my business. One of my favorite judges I used to work for at the state level, he said to me, he used to call me Traylor. He said, Traylor, you don't tell me how to be a judge, and I won't tell you how to run the court system, and we'll get along just fine. And I had to laugh at that because he was an old country judge. And I said, deal. And we had a great relationship. I stayed out of his business, he stayed out of mine, and we had a really good court system. So judges need to avoid meddling in other agencies or departments' businesses. So when we talk about the role of a tribal judge now, where might we look to find what it is a tribal judge is supposed to do? When you take the bench for the first time, where are you going to turn to figure out exactly what you're supposed to do? First of all, I would say look at the tribal constitution. You may not find anything in there that tells you what a judge is supposed to do, but you might, and that's going to be your most significant source of authority. Because tribal council, nobody can take that away from you, and everybody expects you to follow that. The Law and Order Code, generally enacted by the tribal council, this is where most tribal judges are going to find their authority and responsibility, what you should be doing, what you must be doing, and what you have authority to do. There may be some special ordinances outside the Law and Order Code that the council passes, specifically for example, a chief judge, duties and powers of a chief judge. I've seen that before. And then the last place you're going to find it, well, the other one is, well, this is what other judges used to do, and so this has just become part of the culture for a judge to do this. I don't like that because nothing's in writing, and that's just left to too much interpretation, and that's going to get a judge in trouble. And the last one I put is job description, because I think every tribe that has an HR department has a job description for the judge or the chief judge. And I never like relying on those because those are not adopted by the, most of them, these are not adopted by the tribal council. They are not put into ordinance, and they are written by, generally speaking, somebody in HR. Now they may allow the chief judge to have some input in the job description, or they may ask the tribal court administrator. But remember what a job description is. It is nothing that's binding, in my opinion. In every organization I've ever worked in, job descriptions were simply a tool of HR for, first, advertising for the job, and secondly, trying to put the job in a compartment or a category so that they could monitor and do their job as HR people. So I would never look to a job description when I was if I was trying to determine what it is the judge is supposed to do at any level. So some of the roles of a judge, in my opinion, I think judges are arbiters. They ensure that all parties are respectful towards the court and each other. They ensure that the case moves along in an orderly, timely, and predictable manner. And I highlighted timely because it is so, so important. I believe it is the judge's premier responsibility to the citizens that cases get disposed of timely. One of the courts I was consulting on, I asked them if they had any kind of statistical data that was given to the judge on a regular basis, the judges, to show them the age of their cases. And they said, no, but the system can create that. So I asked them to create that for me, and it was very, very disheartening. Some cases, simple cases, were over 2 years old, and they just hadn't had an order closing the case or disposing of the case, and litigants were left hanging. And I found that there were a lot of complaints from citizens to the clerks. When's the judge going to decide my case? When am I going to get a judgment? And the clerks just, they passed it on, but nothing ever happened. So one of the things I did for this tribe is I helped them draft, actually I helped the Judicial Council that oversaw the judges draft timetables for specific types of cases. And this is nothing new, but it was new to them. And I helped them draft an ordinance that made it part of the judge's responsibility to monitor their cases and dispose of them in a timely fashion. There's a saying out there, it's been around forever in the world of court administration, justice delayed is justice denied. Judges have the premier responsibility to manage their caseload, to get cases heard timely. You don't want to rush through it. You have to give the parties time to prepare and present their case. But once the case has been to that stage, the judge has to take responsibility and say, okay, let's get a decision made in this case. Let's sign the order and let's get the case closed. The judge makes sure that only relevant facts are introduced into the matter. And again, they issue timely decisions. Secondly, I think the judge is a legal analyzer. The judge has to decide which laws or law are implicated in the case. You can't simply rely on counsel to provide your legal research for you. You have to do your own legal research. You can use the legal research of counsel as a springboard, which is what I do on the Court of Appeals. I will let them do the initial research, and I'll research the cases that they cite, because many times they misinterpret the cases or they misconstrue them either innocuously or sometimes on purpose, trying to mislead the court. So you can't believe just what counsel tells you this case stands for. And then I try to do some research beyond that to see if there are other cases that they didn't discuss in their briefs. So judges have to take on that responsibility. And okay, let's try to find my other slide. Okay, there it is. The judges play the role of a mediator. They play an active role in getting cases to settle. When I worked for the state court in Idaho, we had a serious problem with jury trial backlog. Anybody that got cited for a misdemeanor automatically asked for a jury trial because their lawyers knew that we couldn't set a jury trial for 6 months to a year down the road. because they were all asking for jury trials. Well, nobody was holding pretrial conferences. So I finally organized the magistrate judges who heard these cases. I said, let's create a pretrial conference, mandatory pretrial conference on all cases where somebody requests a trial. You try to get them to reach a settlement, and you have to be active. You don't just sit there. You have to be active. What evidence are you going to present, Mr. Prosecutor? Well, that sounds pretty good. Mr. Defense Counsel, how are you going to rebut that? What do you have that you think you might present? And the judge tries to get them to tip their hand, and there's nothing wrong with that. And many times the judge is able to say, well, I don't believe that's what the law says. Or, I think that a motion in limine is going to be appropriate in this case. And so they kind of are leading them to where the judge might be. And the judge has to be open. He has to say, I haven't made my decision yet. If you have evidence that's going to convince me otherwise. But if this is all you have today, I'm telling you, this is where I stand. And what we were able to do, we generated statistics that were quite impressive over on a regular basis. 95 to 97% of those cases settled, and we were able to get them off the jury trial calendar. And so it's a simple little tool that I suggest all tribal courts use. I was consulting with one tribal court, and they had this problem, and I couldn't get the chief judge to agree to do pretrial conferences in this fashion. I couldn't understand it, but their problem persisted. How do judges conduct pretrial conference? I think I just kind of gave you an example. And again, it's the judge's duty to manage their caseload. And if you're a chief judge of any tribe, it's probably your responsibility to supervise how the other judges are managing their caseload. And you shouldn't be shy about looking at the statistics. I think a lot of tribes are using the full court system, and I know that that system can generate the statistical data that gives you the ages of cases from the time they were filed, and that should prove quite eye-opening if you will take a look at that. And the trial judges who are managing their cases, they should look at those as well, not just the chief judge or the court administrator. Holding people in contempt, it is a role of the tribal judge that should be used cautiously and sparingly, and imposing sanctions when appropriate. The issue of contempt should be very well researched by a judge, or if you don't have the time or the legal expertise, I suggest you ask tribal counsel to let you use one of their lawyers or intern law students to research the, you can go out there and find research. You don't have to do it yourself, because a whole book can be written on contempt, civil contempt and criminal contempt, which one's appropriate, how to use each one. You can't make the mistake thinking that you can hold people in contempt because you're angry at them or because they did something silly. You have to have legal backing to hold people in contempt, and then, of course, impose sanctions when necessary. Are you going to throw somebody in jail? What is it you're going to do? So you need to have a good knowledge base of the world of contempt, civil and criminal, before you actually think you're going to hold somebody in contempt. Because you may get overturned by an appellate court, or if you do it frequently enough, a judicial council might say, you know what, you can't keep doing this, and we're going to have to make sure you stop doing it. Again, you don't do it out of spite. You have to exhibit patience and calm, but you have to have a really good understanding of the law of contempt. And here's a tricky one. Letting guilty people go free. You know, ask yourself the question, when might this happen? If you're a tribal judge and you're sitting here listening to me, you probably had to do this before because of a technicality of the law. If there was an unreasonable search or seizure in violation of the Indian Civil Rights Act or tribal constitution or both, or a law and order code. And that was the critical piece of evidence the prosecutor had. Let's say it was an assault weapon, a knife. But the search, the way they found it, violated this person's due process. And you as a judge are wringing your hands, and you know that if you grant the motion to suppress, this guy's going to go free because all the other evidence points to him, but this is critical enough that the rest of the circumstantial evidence is not likely going to convict him. And even if it goes to trial, and you suppress the evidence and it goes to trial and the jury comes back and says not guilty, you're going to feel it's because you suppress that evidence. Why is this necessary in the arena of criminal justice? And I say necessary. I don't say, why is this a good thing? Because I don't think it is a good thing. But why is it necessary that we tolerate this stuff in our judicial system, letting guilty people go free? And to me, it's because it keeps the system in balance. You can't have a system where the prosecutors overstep the law just so they can get a conviction without any checks or balance. And that is the beauty of the judicial system of the United States, and the same with the tribal courts, because they are there to make sure that justice prevails, that justice is imposed, and that due process is granted to everybody that comes before them. And at times, if prosecutors and law enforcement don't follow the law, you as a judge cannot let a conviction go through if that's the critical piece of evidence and the rest of the evidence doesn't convict. So some of the cases, this may be a little bit emotional for judges. Domestic violence is a big issue. If somebody is before you on domestic violence as a defendant who did a terrible thing to the victim, and you see that something happened in the gathering of the evidence, that you're going to have to let this person go free. You're going to have to grant the motion to dismiss or the motion to suppress. You're a human being. How does that affect you? How do you deal with that? How can you deal with that? I know at the state level and federal level, they have support systems built in. Even for lawyers, they have a lawyers group that can talk to each other for personal emotions or problems. I've never seen one on a reservation before. But it would be good if you have the ability to create something like that, because judges have to deal with these emotions. They see a lot of bad things as a judge, a lot of bad things, much like somebody that works in ER. They see a lot of bad things that happen to people. And you need an emotional support system for that when those things happen, because they're going to happen. Something I call cognitive dissonance, imposing a lighter sentence than what you would like because the law says you have to, imposing a harsher sentence than what you'd like because of minimum sentencing standards. You may think this person really deserves a second chance and maybe 30 days in jail, but the law says you have to impose 6 months minimum. Again, how do you handle these kind of things internally? You're going to have to deal with that. I think it'd be very important for judges to have some sort of support group that they can go to. We always talk about victims of crimes and all the support systems that are built for them, and I think that's a great thing. But I've never seen on a reservation, a support system for judges who have to see this kind of stuff on a daily basis. And we go back to managing caseload. Clearing your calendar. Don't sit on cases unnecessarily. Make a decision and get it out the door, because you have a responsibility to the litigants. Nobody likes going to court, but they go there when they have to, and they want a quick answer. May not be tomorrow, but it should be as quickly as possible. Close the cases, Dismiss cases for inaction. Don't be afraid to do that. If the cases have been sitting stale and nobody's pursuing it, send out a notice of intent to dismiss and get it off the docket. Being constantly aware of the age of cases, that's what those statistics come in handy. Prodding counsel to move the cases along. One of the mantras for judges is don't let the parties or don't let the lawyers control the pace of the case. You're the judge. It's your responsibility to get this case processed, heard, and decided timely and quickly. Don't leave it to the lawyers. Some judges say, well, I don't care. If plaintiff doesn't care, I don't care. This case can sit here forever. That's not appropriate because, again, I think you owe a responsibility to the citizens and the litigants, both sides or all sides. And again, pretrial conference is a good tool for this. Don't allow unnecessary filings or delays by counsel. Rule on motions or requests quickly and be on top of your docket. I think judges are guardians of civility. Overstepping politicians that might think they can do things, I think the role of the court system is to monitor that, even if you're not a separate branch of government. Abuse of authority by tribal agencies, planning and zoning, terror ordinances, enrollment ordinances. You have to interpret the law in a fair and unbiased way, and by doing that, you sort of pull in the reins to make sure that tribal agencies or departments aren't abusing their authority. Same with law enforcement and prosecutors or unethical public defenders or advocates that may come before you. Providing a forum so disputes can be resolved civilly. And education. Judge has to stay educated on changing law. Again, not all state law is going to apply to tribes. It's going to depend on what your law and order code says. Not all federal law is going to apply. But you have to be competent in legal research. And if you as a tribal judge, legal research has been made pretty easy in this digital age. Searching through Westlaw is pretty much like Googling something. You just type in some words, type in the subject that you're looking for, and you're going to get a whole list of cases. And then you have to be diligent enough to read those cases and see if they even apply to the issue before you. But like I said earlier, you can't rely on the legal research conducted by counsel because they're pushing an agenda from opposite sides. And so you're the one that has to say, okay, I've read what you put, I've read what you put forward. Now I'm going to go and do my own legal research to see if you're both on point or if you're not. Judges have to be excellent communicators. And to me, this means reeling in your emotions. I've seen judges in court yelling at people, which is totally inappropriate, because the judge lost his cool. He didn't control his emotions. And when your emotions are out of control, you cannot be a good communicator. I've seen judges who should have been upset by what was going on in the court, but they just kept their calm. They talked to the parties and lawyers just like this, and they got order restored in their courtroom. You can't let other people in your courtroom dictate your emotions. You have to, and that's the part, in my opinion, of being a good communicator, not only orally and verbally, but in writing. When you're writing opinions or memorandums, even orders or judgments, precise, be concise. Just state what you have to state. Leave out the emotion. Again, and remain impartial and fair-minded. And finally, be a cooperator. As a former court administrator, I found this to be the most important thing for me and, quite frankly, for the entire judicial system. Because I've seen judges who work with the entire court staff and all departments in the court system, whether it's probation, pre-sentence investigation, prosecution, advocates, public defender, court security, tribal court administrator, clerks. A cooperator judge is a godsend to court staff because they don't walk around the courthouse blustering and barking at people, abusing their power and authority. They want to help. The best thing in the world to me is when a judge came to me as a court administrator and said, I see Judge X is out sick. Do you want me to take her cases today? I said, what? Are you serious? Yes, please. That's exactly what I need. Or I see that Judge X has several jury trials going today and he can only do one. Why don't you let me take the other one so they don't have to be postponed? That's a cooperator. Somebody that's willing to be flexible with court administration and all the players in the court system. And why not? Why not do that? It'll only make your court system a better court. So this comes to the end of my presentation, and I would like to open it up and ask, are there other roles a tribal judge assumes in your jurisdiction? Because I don't think my list is exhaustive. This is just my list based on my experience. But if there are other things that judges do, I think, that might be included in the role of a tribal judge, and it would be wonderful if you could share those with us. So, Jessica, I assume that they can do that on the chat.
Yes, I just wrote that people could do that in chat, or if somebody wants to talk out loud, they can raise their hand and I can unmute their phone, or if they're participating via their computer, I might even be able to turn on their microphone.
Okay. While we're waiting, I will say that the courts that I've consulted with or worked with in the past, just like any court, any state court that I worked with as well, most of the judges want to do the right thing. They really are trying. Most of them were not law trained, which makes it even more difficult for them. But in some regards to me, I think that can help make them a better judge as well. I've been pleasantly surprised to see that most judges, the tribal court judges that I've worked with, are good people. They want to do the right thing. They're excited about being a tribal judge. They want to see if they can make a change and do things right. And that's just a very pleasant thing for me to see and to hear. The other thing I would suggest, as I think I probably alluded to earlier, was tribal judges, please work with your tribal court administrators. I've been a tribal court administrator. I've been a state court administrator for most of my career. And now I'm a judge. And even in my position as a court of appeals, I don't have a lot of daily contact with court staff. But I still see the frustration sometimes when the trial judges don't work together with the court administrator, and it just creates a bad situation for the court, for the litigants, and for court staff. The courts I consult with, I try to get the chief judge and the tribal court administrator to work as a team because they all have the same goal in mind, and that is to administer the court system in an efficient and effective way, and they need to be a team, and they shouldn't be working against each other. So I'm not seeing any answers to the question, or if there's other roles a tribal judge assumes, maybe we touched on all of them. So we've been going for about
comprehensive.
Well, I appreciate that. So,
Great. So I think, Rebecca, we'll turn it over to you to close us out.
Sounds good. Thank you, Judge Traylor, so much for that very interesting and informative presentation. Before we conclude, I just want to take a moment to talk about NAICJA and our work in tribal communities. For those of you who are new to our webinars, NAICJA is a tribal justice professional organization whose goal is to build and enhance tribal court capacity. We do a very broad range of work for tribal communities, including training both remote and on-site, as well as technical assistance to support tribal courts. We're also TA providers for the Bureau of Justice Assistance, Coordinated Tribal Assisted Solicitation Purpose Area 3 grantees. Another part of our work is the Tribal Access to Justice Innovation website. This website allows us to highlight and share different programs in tribal communities. If you know of a promising program, let us know about it. And if it's not already highlighted on the TAJI website, we can go ahead and share it. That website is tribaljustice, altogether, all lowercase, .org, tribaljustice.org. And again, our goal with that is to learn about emerging practices and share that information, as many tribes are addressing common challenges. That concludes our webinar. My email address is Rebecca, R-E-B-E-K-A-H, @NAICJA.org. I believe Jessica will put it up on the slides here at the end. If anyone has any questions or TA requests, please email me. Otherwise, thank you to our presenter for your presentation today, and to NCJ, FCJ for hosting, and thank you everyone for joining us today.
Thank you, Rebecca. I'd like to let everyone know that we've recorded today's webinar, and that will be posted online both at the NCJ, FCJ website and the NAICJA website. So if you weren't able, if you had a friend that wasn't able to participate today and you'd like to share this webinar with them, you'll receive a notice when it is posted. Right now I'm going to post